Good day, Internet. Chavez and Valco here, the key to your immigration solutions. My name is Benjamin Hamilton. I'm a senior associate attorney here at Chavez and Valco. My background is in employment-based immigration law. So when you see me or my colleague, Andrew Craven, that is what we're here to talk about. Now, today, we're actually not here to talk about a visa category or a residency category like we normally do. Here, we're actually to talk about some recent news involving Facebook. And of course, you're thinking, well, does this have to do with all of the papers that were released and how Facebook's supposedly going to destroy modern society? No, none of that. Actually, we're here to talk about a recent complaint filed by the Department of Justice against Facebook regarding their recruitment practices related to sponsoring their foreign employees. So, a little bit of background. In December of 2020, the Department of Justice, specifically the Executive Office for Immigration Review, filed a complaint against Facebook, alleging that Facebook intentionally discriminated against workers. Now, this was done under 8 USC 1324B, right? Which states the following. It is an unfair immigration-related employment practice for a person or other entity to discriminate against any individual with respect to the hiring of the individual for employment or the discharging of the individual from employment because of such individual's national origin. So you may be asking yourself, well, who is the DOJ alleging that Facebook discriminated against? You might think, well, this would be a lot of maybe against their foreign employees. No, the DOJ is alleging that Facebook discriminated against U.S. workers, right? Specifically, when attempting to permanently hire employees holding a temporary immigration status, the DOJ alleged that Facebook intentionally discriminated against potential U.S. workers by designing a recruitment process that deterred U.S. workers from applying for advertised positions, not considering U.S. workers for advertised positions, and hiring only temporary visa holders for the advertised positions. So 3 things here. I guess we got to walk this back a little bit and talk about what are some of the basics of the actual PERM process that we're discussing. So the PERM labor certification process, it's administered by the Department of Labor, not the Department of Justice, right? The Department of Labor. The Department of Labor requires the employer to attempt to test the labor market by using 3 mandatory recruitment methods. So again, this is if an employer is trying to permanently sponsor a foreign worker, essentially get a green card for this foreign worker. So 3 mandatory recruitment steps. They must post the position to a state workforce agency job board, right? All states have these. They must post a notice internally at the place of employment. So it's usually a piece of paper that they put up in like the break room. And they must advertise the position in a major newspaper 2 times, right? Usually this is 2 Sunday ads. Here in the Dallas-Fort Worth area, that would be the Dallas Morning News would be the newspaper you would use. But for professional positions, which pretty much all the Facebook PERMs are for professional positions, the employer must also use 3 additional recruitment methods. And now there's a list of around 10, and you only have to do 3 of the 10. So this includes job fairs, the employer's website, a job search website. This would be like monster.com, Career Builder, LinkedIn, on-campus recruiting, a trade or professional organization or magazine, private employment firms, an employee referral program with incentives, campus placement offices, local and ethnic newspapers, and radio and television advertisements. So, how did Facebook conduct their recruitment? Because I think a lot of you are thinking, well, Facebook must have done something wrong. So, what is it they did wrong in the recruitment? Well, here's what Facebook actually did, right? They did post the positions to the state workforce agency job board. This mostly would have been in California. They did post notices internally at the place of employment. They did post 2 Sunday ads in a major newspaper. Most of these were in the San Francisco Chronicle, based on where Facebook's located. Facebook did post the positions in a professional journal. Facebook did post the positions on a job search website. And Facebook did post the positions in a local newspaper. So this would be other than the San Francisco Chronicle. Well, this means Facebook did comply with the laws and regulations as administered by the Department of Labor. They complied with the 3 mandatory requirements and they complied with the 3 additional requirements. So, in fact, between January 2018 and September 2019, which is kind of the period in question in the complaint, Facebook filed 2,651 perms, of which 2,606 were certified, which is 98%. So, Department of Labor looked at Facebook's practices and said, in 98% of the cases, everything's good here, right? They approved them. So clearly, the Department of Labor didn't have any issue with how Facebook was conducting its recruitment practices. Just on a side note, the average salary for all these perm positions was $156,000. So these are not like entry level, low end positions, right? These are clearly professional positions, most requiring, a degree and experience. So then, what is the DOJ, or what did the DOJ allege that Facebook did wrong? Well, Facebook advertised its non-perm position. So all the just regular recruitment was all advertised on Facebook's external careers website and on Facebook's intranet. So most big employers, if you go to their website, you look around, a lot of times maybe up at the top or down at the bottom, you'll see some that says careers, and you click on that, and they have a whole section of their website where they post all of their open positions, right? And Facebook does this. And for all of their non-perm positions, applicants could submit a electronic application, right? Usually through the careers website, right? So they posted them. They posted their non-perm positions on their website and allowed online applications. The perm positions, on the other hand, as we mentioned, they were not posted on the careers website. Facebook did not accept online applications for the perm positions. All the perm ads said that the applications had to be mailed in. If a qualified U.S. worker applied to a perm-related position, Facebook actually directed the U.S. worker to an open non-perm position, meaning if someone applied to a perm position was qualified, they hired them. They just directed them to another position. That one's kind of a no-no. If a qualified U.S. worker applied to a perm related position and Facebook was unable to direct them, so they're like, "Hey, we have an art director position open on our Facebook careers website, but there's also this art director perm position." They could redirect them, right? But if there was no position to redirect them to, then Facebook stopped the perm process, which is actually what you're supposed to do. If you test the labor market and find a qualified U.S. applicant, you're supposed to just stop the perm process. You can't move forward with it. If you were to, and then the Department of Labor finds out, you get in trouble, and you can, they'll deny it, and you can get penalized. So again, they weren't posting on their external on their careers website. They're requiring mail-in applications. They were redirecting qualified applicants. So here's some of the data that the Department of Justice was citing to and kind of in support of their position of discrimination. They were saying that the non-perm positions received at least 104 applications per position. Whereas the perm positions, 80% of them received 0 applicants, 0, right? Around 18% received 1 applicant. And only 0.3% of their perm applications received 2 or more applications. So clearly, just based on where the perm ads are being placed, people weren't seeing them, right? Which, to be honest, is kind of the point from the employer side. They want to place these ads somewhere that is allowed, but will get the least amount of visibility. And the Department of Justice also alleges that there were at least 4,000 applicants to non-perm positions that were qualified, but were passed over because there was a more qualified applicant. and that none of those 4,000 were considered for the perm positions. It was kind of like it had separate databases. So there's all these people applying to the perm positions, and we're only considering them. And there's always people applying to the perm positions, and we're not kind of like considering them across. So here is the key to the complaint, right? If we were to just kind of sum this all up, why does the Department of Justice think that Facebook was discriminating against U.S. workers? And this is actually a quotation from the complaint itself. It says, the Department of Labor has made clear that in conducting this recruitment, employers must also engage in a good faith search that closely resembles the employer's normal recruiting process. And there's a citation. It's a case called Matter of American Specialty Pharmacy, which was considered by BALCA. BALCA is an administrative appeals board within the Department of Labor, right? Here's the problem with the Department of Justice's statement. The second half of the statement, while it sounds logical, that closely resembles the employer's normal recruiting process. While that sounds logical, it's complete BS. It's made up. Doesn't exist. That line does not exist anywhere in law or regulation. And this is actually kind of a common practice if you work in immigration, where the agencies kind of make stuff up. Now, that case, Matter of American Specialty Pharmacy, what it does say is, this is a quote, we have interpreted this regulation as placing a burden on the employer to conduct a good faith recruitment effort, right? So obviously the Department of Justice saying you have to conduct a good faith recruitment, that is supported by the law. That is true. It's just the second half that's BS. This case, Matter of American Specialty Pharmacy, cites another case called East Tennessee State University, which says, quote, employers seeking permanent labor certification may have to conduct their recruitment in a manner different than they would normally in order to ensure that the position is clearly open to all qualified U.S. workers. Wait a second. The case that the DOJ cited to doesn't say what they wanted to say. It says the opposite. It says that the employer may have to do things different in the perm process than they would normally do. And the DOL, the Department of Labor, actually confirmed this in a 2008 memo, which says, given that the Permanent Labor Certification Program imposes recruitment standards on the employer that may deviate from the employer's normal standards of evaluation, the department understands and appreciates the legitimate role attorneys and agents play in the Permanent Labor Certification process, right? The BALCA has said that, hey, yeah, your perm recruitment processes may have to deviate from your normal processes. The DOL agreed with that, right? And it makes sense, right? Because, for example, as we said, one of the mandatory recruitment practices is that you have to place 2 Sunday ads in a newspaper. Who places 2 Sunday ads in a newspaper? I'm willing to bet right now, if you were to open a newspaper from any major city and you were to look at all of the job ads in there, I think a lot of them, most of them maybe, are going to read like perm ads, meaning that 90% of the ads in there are BS. They're just perm ads that are in there because we have to. Why do we have to? Well, because most of our modern immigration laws were written 30 years ago and haven't been updated. And another thing to note is that requiring mail-in applications is not a violation of the DOL rules. So the key is to say here that they're saying that if your perm practices deviate from your normal practices, that's discrimination. When in fact, BALCA has said that we can understand that sometimes they will deviate, and the DOL has agreed that sometimes they will deviate, because in fact, some of the things that they require by law are deviations. So a lot of this doesn't make any sense, and I think a lot of people had hoped that the Facebook would fight this, that they wouldn't cave, because otherwise it would establish a bad precedent. But anyway, I think maybe in part because of all the other stuff going on with Facebook right now, they decided to settle. Right? They did not fight this. So the settlement agreement came out, I think last week. And so we're going to look a little bit about what the settlement says. So this is what Facebook agreed to. Facebook is not required to admit guilt regarding the alleged violations of 8 USC 1324A, saying they discriminated. Facebook will pay 4.7 million in civil penalties to the Department of Justice. Facebook will pay 9.5 million to a settlement fund, which that one's going to be interesting. Hypothetically, I guess if you were a U.S. citizen, applied to one of these jobs and didn't get hired, you may be able to make a claim. Facebook will post all perm positions on the Facebook's career website, and those will include a requisition number so they can kind of match everything up. So again, of the three additional recruitment methods, one of those has to be on their careers website, and then the other two can be whatever. Facebook will accept electronic applications for all perm positions. And this not only includes through their careers website, but this also includes through the state workforce agency if they provide that. Facebook will not require mail-in applications. Facebook will enter all perm applicants into the company's recruitment systems. Again, remember, they weren't concerning people that were applying for like the art director non-perm position for the art director perm position. They're saying, well, if we put all these people into the same database, then they'll be able to consider anyone for any related position. Facebook will provide the DOJ with recruitment reports every 6 months for 3 years. So the DOJ is going to be checking up on them. And Facebook will provide training to all employees involved in the recruitment process to ensure that this type of stuff doesn't happen in the future. Now, here's the important question. What is the fallout? Why is this settlement potentially very dangerous? One thing I want to hold out here, I want to say, is that this began under the Trump administration. So there is all likelihood that this was carried forward because they had to. But that going forward, the Biden administration is not really going to pursue any of this. But we don't know that yet. We don't know. What we do know is that this actually is very dangerous because it could lead to a lot of things that it could have a chilling effect on employers' abilities to permanently sponsor their employees, their foreign employees. First and foremost, the DOL imposes additional requirements on the perm recruitment process, not found in the real world. We already talked about the 2 Sunday ads being a key one, running a state workforce agency ad. Not everyone does that when they're recruiting. Another requirement that the DOL imposes on perm cases is that if an employer contacts an applicant and the applicant doesn't respond, so they get an application in the mail or an email, and then they reach out to that applicant maybe appears that they might be qualified, meaning that triggers the employer to have to interview that client, that applicant. So if you look at an applicant and it's like they don't have the degree that the position requires, you can just not consider them. But let's say they have the degree, but you're a little iffy on the experience, right? Then you have to contact the employee and you have to interview them to make sure whether or not they qualify. But let's say you contact the applicant and the applicant just ghosts you, doesn't respond. Well, the employer has to demonstrate that it indeed contacted the applicant and must prove that the candidate received the communication. So there are some employers that will send out certified letters to applicants that they attempted to contact, didn't respond. So the employer is sending out a certified a letter saying, hey, we attempted to contact you. And then, of course, because it's a certified letter, they have proof. Why is this dangerous? Well, because if the perm recruitment process didn't match the real world, their normal recruitment process, what's stopping the DOJ from coming back and saying, well, why doesn't your real world process match your perm process? Yet, why are you not running 2 Sunday ads in your normal recruitment? Why are you not, certifying that you attempted to contact U.S. workers? Right? At the end of the day, the employer is required to conduct a good faith test of the labor market, but the employer is under no obligation to hire a qualified applicant. That is key here, right? If the employer finds a U.S. worker who is qualified for the position, they just stop the process. But again, what's stopping, the Department of Justice cited the fact that, hey, you ran 2,600 perms and in all of them you hired the foreigner. Well, even if I align my perm practices with my real world practices, I still may have the same outcome. Where for all of my perm positions, and all of them, I 100% of the cases, I hire the foreigner. Why? Because if I do find a qualified US applicant, I just stop the process, which is okay, which is what everyone does. But it seems that the Department of Labor has no problem with that, but apparently the Department of Justice does. So there's nothing stopping the Department of Justice from coming back later and saying, well, yes, you did align your practices, but you still refuse to hire the US worker. And of course, the response is, well, I'm not required to. I'm only required to stop the process, which I did. And why would the employer stop the process rather than hire the US worker? Because let's be honest here, what's happening? It's not an open position. The Department of Justice is not, sorry, the employer is not actually attempting to find a US worker. Because guess what? They already have a worker in that position who's working for them. It just so happens that that worker is on a temporary visa, a non immigrant visa, like an H-1B. And they're trying to transition that worker from an H-1B, a temporary visa, to a permanent visa, a green card. So they're not testing the labor market because they want to hire a qualified US applicant. They're testing the labor market because the law requires them to in order to keep the guy they already have. So in most of these cases, they're never going to hire a qualified US applicant if one applies to the position. They're just going to stop the process because that the position's already filled. The other way around this, and with a company like Facebook that's bigger, is what all they're going to do is rather than posting, one job ad for an art director, well, they're just going to say we have multiple openings. We need 10 art directors. When they're really trying to sponsor, this one guy, maybe they have right 5 open positions, including the one guy they want to sponsor. But they have 10 open positions, 5 qualified applicants apply, and they hire those 5. Well, there's still 5 open for them to sponsor the immigrant. So you're just going to see them bringing everything to their careers website, but probably increasing the amount of open positions. You also may see them bifurcating job positions, right? Same thing. Well, we just have an art director, which is, again, this is actually a position they pointed out in the DOJ complaint. That's why I keep bringing back to art director. What you're probably going to see them do is saying, well, if we just put our art director, that's kind of a somewhat ambiguous position that can get a lot of applications when we're trying to sponsor this guy over here, where we do have some positions we want to fill, but we also want to sponsor this guy over here. So I think what you're going to see someone like Facebook doing is bifurcating a lot of these positions to be like, well, there's an art director 1, and these are its requirements, and there's an art director 2, and it has these requirements, and art director 3, and it just so happens that the art director 3 kind of lines up with the guy they're trying to sponsor. So I think you're going to see a lot of where they're taking positions and splitting them up into multiple different positions that have sort of different little nuances to their job requirements. Um, we are going to below include some links to some really good resources. I want to especially name one of those. It's Cyrus Mehta, who is kind of known in the immigration world as like the immigration scholar, and always posts really good uh, breakdowns of these things. So obviously, if you want to read a detailed breakdown, go read his article. We'll link below. But I do want to kind of pull a quote from the end of his article, which says, the DOJ complaint is aimed at discouraging employers from sponsoring skilled foreign national workers for permanent residence, lest they be accused of citizenship discrimination after following the labor certification process. So what this really comes down to is you have one agency that says, these are our rules. As long as you follow them, you're good. And they did. 98% of their perms were approved. But you have a totally separate agency that's using a law outside of the DOL rules to come in and say, well, this is discriminatory. And the employers end up just kind of stuck in the middle. Well, what do you want us to do here? It's not our fault that these laws are, some of them poorly written and some of them just extremely outdated. And of course, the person who's really getting hurt here are these foreign employees, a lot of whom have been working for the company for years, probably went to school here, got a job, they've been working here for years, and are now being faced with potentially not being able to stay, to apply for residency. So even if an employer mirrors its real world recruitment with its labor certification recruitment and even goes beyond it, the employer is still vulnerable to a citizenship discrimination claim by the Department of Justice. So the big key here we're going to find out, and we're not going to know this until we start to see some reporting from attorneys. The real question is here is what the DOL going to do? Is the DOL going to look at this and just go, whatever, that's the DOJ's thing, right? Our rules are our rules, and we're going to keep enforcing them as we have. We don't care. Or is the DOL going to look at this settlement and say, aha, there's a couple things here we need to focus on and go after, right? So is the DOL suddenly going to start auditing more people and looking at their recruitment practices and demanding information as to whether or not their perm recruitment practices match their regular recruitment practices, and then denying perms, right? That's kind of the big scary thing here. Is that going to happen? And is that going to include things like requiring mail-in applications? And we're just going to have to wait and see what happens if the DOL releases any new FAQs or any memos, or if we just start seeing reports from attorneys about audits and denials. Of course, if you see audits and denials, then you'll start to see appeals that will work their way back up to BALCA, and then we'll at least get a definitive decision from the Department of Labor in terms of how they view these things. But again, whatever the Department of Labor says doesn't bind the DOJ, who can still, even if the Department of Labor comes back and sort of affirms the fact that your normal recruitment and your perm recruitment may diverge, even if this gets litigated and BALCA confirms that that is okay that they diverge, it's still possible the DOJ can come in, swoop in, and say discrimination because they do diverge. So at the end of the day, this is a bit of a kind of crazy case that's put us into a kind of state of limbo. The number one recommendation I would give right now to any employers listening to this, or any employees that are worried about this, is you may want to take a look at your perm practices and start looking if you have large divergences between your normal practice, and seeing where you can bring them closer together. It may not be 100%, but closer together to avoid potential problems. Number one on that list would be, hey, employer, if you post jobs on your company website, then you probably should be posting your perm jobs there too. And if you allow electronic applications, you probably should be allowing electronic applications and not putting mail in. Unfortunately, what that's going to do is it's going to increase the number of applicants, which means it's going to be harder for you to sponsor the people you want to sponsor, because it's more likely you run across a qualified U.S. applicant and will then have to stop the perm process. But what we really hope here is that we can push the DOL to maybe modernize a little bit, to implement maybe some new rules. They've actually done that with the H-2A, which right now has it's the only visa where they've modernized the Sunday ad rules and kind of actually gotten rid of them and allowed electronic ads like, Career Builder and LinkedIn. So on the H-2A, they did modernize, but everywhere else they haven't. Anyway, guys, I hope you enjoyed this discussion about the DOJ Facebook complaint and settlement regarding their perm practices. I hope you learned something here. Like I said, we're going to link to a couple of resources down below. Otherwise, hey, please stay tuned for our series on all the different non-immigrant visas and residency categories. Also, if any late breaking news, we'll be back here to dissect it. Otherwise, hey, if you have any questions or concerns, you can email us, call us, go to our website where you can actually schedule a consultation. We're here to talk with you about anything immigration related, but of course, especially about your current perm practices and what you may need to change or update. But otherwise, thank you for tuning in, and good day, and we'll see you later.